online for you. We appreciate the funding of this project from the Division of Housing and Community Development from the Department of Workforce Services, the funding for our land use library from the Ombudsman's Office and the Department of Commerce. We invite you to enjoy the materials for this session as well as for others at our land use library. And please feel free to offer comments, questions, observations at info@utahlanduse.org. That is info@utahlanduse.org. Let's turn the time over to Kyle and have him discuss with us vested rights.
Okay. Thanks, Craig. It's great to be here with the opportunity to talk a little bit about vested rights. My screen hopefully should be shared at this point. So vested rights is not an overly complicated, complex topic. I've tried to kind of do a succinct overview for this presentation. As Craig mentioned, the materials that we have online are more voluminous and they're heavily footnoted, as any package of good materials are. So for details, please refer to those, and hopefully those will give you a good background and a good launching pad to answer any questions that you might have. So really briefly, we're going to talk about three things today. We're going to talk about the steps or the requirements for acquiring vested rights and kind of what those rights are. Talk about the exceptions to the vested rights doctrine. And then we're going to touch briefly on vested rights cousin, although there's some distinctions between vested rights and the doctrine of zoning estoppel. So to start out, I think that it's fitting that I'm presenting this topic because I'm based up in Logan, up in beautiful Cache Valley, and this doctrine in Utah was vested rights was first introduced in the case on the slide, Western Land Equities versus the City of Logan back in 1980. And so stop me if you've heard this fact pattern before, but what happened was the readers in Logan acquired about 18 acres of property within the city limits. A few years later, their property zoning was changed to M1, which permitted certain single family dwellings on their property. And so the readers decided to develop the property to put in affordable single family residences. They submitted their application to the city, and the application bounced between Planning Commission and the City Council, at which point the Planning Commission decided that it didn't like the idea of having subdivision in this M1 zoned area, and as a result, denied the application. So this, and in the interim, they actually passed an ordinance that would have changed that zoning designation and would not have permitted the readers' desired use. So what ended up happening, obviously, is the readers went to court, and the court developed, after it went into it, it's a really great case to go in and to read about the background and the rationale. The court reviews multiple states in the way they approach these issues. Rejecting, or declining to use the concept of zoning estoppel in this case for reasons that we'll talk about in a little bit, but instead adopting the doctrine of vested rights. I think this quote from the court distills it pretty well, where it says a property owner should be able to plan for developing his property in a manner permitted by existing zoning regulations, with some degree of assurance that the basic ground rules will not be changed in midstream. An applicant for approval of a plan and permitted use should not be subject to shifting policies that do not reflect serious public concerns. And so what are vested rights? Vested rights are essentially a snapshot in time of the legal and regulatory structure against which a particular use of land application will be compared and will be governed. And so that doctrine has been in Utah since 1980. In 2005, it was actually codified in our statutes, and so you'll see in the materials and in the presentation, you'll see references to Title 17 and Title 10, because the doctrine applies equally to counties as well as to municipalities. The statutes are, for all intents and purposes, identical. And so this is what the statutes, the statutes are long. We've got lots of caveats to them, but essentially what the statute says is that an applicant who submits a complete land use application and pays all the fees is entitled to substantive review of the application under the regulations in effect on the date the application is complete. And so again, that's the snapshot of time against which that application will be compared, those regulations and laws in effect. Okay, so there are essentially 3 steps or 3 requirements before we get to the exceptions that are needed to acquire vested rights, to actually create that snapshot in time of laws and of regulations and the state of things. So the first thing is to have a completed application. Okay, and so under the statutes, a completed application, it's considered complete and submitted when the applicant provides the application in a form that complies with the regulations of applicable ordinances and pays all the applicable fees. So you've got to use the correct form, provide all the information required in the form and required by the ordinances and regulations, and then actually pay the fees. Okay. At that point in time, the land use authority has a brief period of time in which to determine whether or not that application is complete for purposes of substantive review. So importantly, there's no, and we'll talk about this a little bit later, there's no placeholding. Applicants cannot submit, incomplete or non-compliant applications in order to kind of hold their place in line as far as the laws in effect at the time, and then go back and correct them. Rights cannot vest until the date in which a completed compliant application is actually provided. Okay. And not a lot to talk about there, and it's laid out in the statute. The second step is to actually have the application conform with the land use regulations, decisions, and development standards at the time of submission. If it doesn't comply, it's going to be rejected, or it can be rejected. There's not going to be a placeholder, not a chance to go back and amend and revise, and then have that application relate back to the time that it was first submitted. And this quote I have in here from Springville Citizens for a Better Community versus the City of Springville is a case in which the City of Springville actually approved a certain a development that neighboring residents didn't like, and they approved it even though it didn't, even though the development did not actually conform to the ordinances in place at the time, and the court found that was improper and said that the city has to apply the laws as they are in place at that time, and can't change the rules halfway through the game. Now, one thing that's an interesting twist are our populist rights of referendum in the state of Utah. So after after certain laws are passed, the Utah citizens can actually challenge or submit new laws to the voters by referendum before that ordinance takes place, or before that ordinance actually goes into effect and is enforced. And so what this creates is a situation in which a new ordinance is passed, and then a land use application is immediately filed. However, if that land use application is compliant with that new ordinance, but that new ordinance is then subsequently challenged or subsequently affected by a referendum, the vested rights the applicant won't have any vested rights in that particular ordinance, because the way the courts have interpreted and defined it, because that ordinance didn't actually go into effect until it cleared the hurdle of the referendum or the time for referendum had passed. And so it's something to keep your eye on. If you happen to be submitting an application that is subject to a brand new ordinance or law, to make sure and to kind of watch that there's, if the right to referendum has passed on it, or if the referendum process has finally run its course. So the right to referendum again can play with that a little bit. So that's step number 2. And then step number 3, and this is all statutory language, requires that for rights to actually vest and to continue to be effective, the land use applicant has to proceed with the approved development with reasonable diligence. Okay, if the applicant fails to do so and doesn't proceed, then it'll lapse and require a new application. The statute doesn't have a particular time limit, but what this quote from Spencer versus Pleasant View City points out is that, again, it's the placeholder problem. A land use developer cannot come in, submit an application, get it approved, and then sit on it for an indefinite period of time. To do so and claim that the rights in the current ordinances have been vested would severely hamper a city's or a county's ability to change and evolve the land use applications. And so if it lapses, that would require a new application, and rights would only vest at the time that new, completed compliant application was submitted. Couple of really quick notes about the nature of vested rights also before we move on to the exceptions, is that you only require rights, your rights only vest as to the information included in the application. So an application for one building permit, for a lot in, one subdivision does not vest rights in subsequent applications for building permits, even though they might be in the same subdivision. And then, but that said, once rights are vested and then an application is actually approved and final, those corresponding vested rights cannot be revoked. Even if elected officials later on disagree with the decision beforehand. And another thing that I should point out is that just because rights vest doesn't mean that the application must be approved. All that vested rights mean is that the applicant has the right to have the application, reviewed in light of the ordinances in place at the time, right? If they don't comply, then obviously, rejection is appropriate, requiring a new submittal and then a new date for vested rights. Okay. Let's talk about exceptions. So there are 2 exceptions. These are exceptions that the Supreme Court came up with in 1980, and they're actually in the code now as well. So the first one is a compelling public interest, and the second is pending legislation. So first, this is what the statute says, that the land use authority can deny a complete application, even if it complies, if on the record the authority formally finds that a compelling countervailing public interest would be jeopardized by approving the application. So this is kind of an emergency stop that can override the vested rights doctrine. Now, really important is that the countervailing public interest has to be fundamental, seriously threatens public health, safety, or welfare, so that your typical run-of-the-mill land use issues, like economic considerations or compatibility concerns, neighbors to a proposed multifamily development are up in arms about the approval. Those are not fundamental, compelling countervailing interests. What we're really talking about are extraordinary circumstances. Examples would be, newly discovered geographical or geologic issues with soils or with neighboring properties, or previously unknown environmental hazards that come to light but have not yet been addressed, by the lawmakers. Those would be compelling countervailing reasons. And so the list is going to be very short. And again, the authority is going to need to specify that interest in writing in connection with the denial in order to get the benefit of that exception in the statute. So that's a public interest exception. The pending legislation exception basically states that if prior to the date that the completed application is submitted and the fees are paid, the government has formally initiated proceedings to amend the applicable regulations that would then actually prohibit approval of the land use application. So if the government has already put the wheels in motion for changing a relevant ordinance, the rights can't, the rights won't necessarily vest at that time. Again, the process has to have been started before. It can't start concurrently, or it can't start after. One interesting caveat, however, is that denial is not mandatory. So if a submission or if an application submitted that complies with law X, but before that time, the process had started to change law X to law Y, which would actually require rejection of the application. Because that law has not been put into effect yet, the land use authority still has a discretion to approve the land use application under law X, or it can obviously wait until law Y is passed, because the pending legislation has been put into motion, the rights don't vest. Again, this has to be an actual law. This isn't just conceptual discussions or potential or plans that a municipality or that a county might want to take. Having those discussions in a city council meeting, it has to actually be a law, something written down that a land use applicant can compare the application to. One interesting note is the potential effect of citizen initiative. Again, citizens can start the lawmaking process. It hasn't been addressed in Utah courts about whether or not a citizen initiated law would qualify for the pending legislation exception, because the code states that exception applies when the county or municipality initiates formal proceedings. So that'd be something to keep your eye on if a law or if an application is affected by a law or an amendment that was put into motion by citizen initiative. Okay, I told you this was brief. Our last bit that we're going to talk about is zoning estoppel. Zoning estoppel is often confused with the doctrine of vested rights because it gets at the same problem, and that is preventing the government from essentially pulling the rug out from under a developer. Zoning estoppel, however, is not statutory. It's judicial doctrine in the common law. Although parties invoke zoning estoppel in reported cases a lot, it is rarely successful. In fact, in my research, I've only been able to find one case in which someone was successful with that argument. That was back in 1976 and had a pretty good dissent in the opinion. And those are it basically involved discriminatory application of zoning ordinances. So it's pretty difficult, and the reasons for that is because of the elements. So the first thing that has to happen is that the government has to engage in a clear, definite, and affirmative act that can be relied upon. So we're talking about the government itself, not necessarily employees or other agents. This isn't like a corporate agent type analysis. We're talking about actual probably elected officials or folks who are in position to speak for the government itself. So so if you go into the planning office and talk to just an employee there who says, oh yeah, go ahead and do X, or oh yeah, it's fine to do Y, and then the government turns around and denies something that you do, the argument to go back and say, hey, this is the advice I was given, is very unlikely to get you anywhere. Okay, so that's a pretty high bar for property owners. It's got to be an official, clear act. Then there's got to be reasonable, good faith reliance on that guidance, which again is difficult because everyone's presumed to know the law. And lots of times the argument is that the city should, or the city, the municipality, or the county should have acted, but did not. Which again is even more difficult when you're trying to allege that an omission occurred, because you've got to prove that the government had an absolute duty to act, but did not in an official capacity. So again, maybe not as difficult as number one, but number two is difficult as well. And number three, the substantial change in position requirement is what really finishes off zoning estoppel, because to show a substantial change in position in reliance, developers, applicants need to show typically that actual physical improvements and money was expended to physically improve the property at issue. So, buying property or just owning property doesn't satisfy the standard, or spending money on, options for engineering or planning. That's not going to work. You're going to need to show that there was some, significant physical construction or other development of the land. And that's mainly the reason that the Supreme Court back in 1980 developed the vested rights doctrine, was because, there could be some significant reliance and, by a developer who bought property and submitted an application under certain ordinances, and then gets planning approval denied, which means by definition there couldn't be any construction on the property. That there couldn't be a substantial change in position under these requirements. And so for that reason, you've got the, kind of this companion cousin doctrine to zoning estoppel. So again, thanks for everybody. That was really brief. It's not a complicated doctrine. It's got a couple of caveats that are in the statute. Please refer to the materials, and hopefully those provide all the cases and statutes you could possibly need to evaluate an issue. So thank you.
Thank you, Kyle. It's a pleasure to have had your help with this seminar. And we also want to remind everyone, as Kyle said, these materials will be available not just at the workshop's website, which is a tab on the utahlanduse.org webpage, but also in the land use library going on in the future. Thank you, Kyle, and thank you for all who participated.